If everyone's ready. Hi, my name is Lauren Weinstein. Carl said he was the article editor, but that's not true. There's two. I'm the other one. And thank you for coming to our second panel. This panel is going to discuss critical issues in redefining civil rights for Muslims since 9/11. We hope that you'll come away with a more refined picture of the state of civil rights for Muslims today, and also that it will be an opportunity for some self-reflection about the evolving moral and constitutional standards regarding civil rights for Muslims. So as for our panelists, we have Professor Natsu Saito. Professor Saito attended Swarthmore College, Georgia State for her Master's of Education, and Yale Law School before going to work in private practice and teaching at Emory Law School. She is now a full-time professor at Georgia State University of Law. Her academic endeavors have focused on issues involving race and human rights within the United States. Professor Saito's many professional activities have included serving on the Georgia Supreme Court's Commission on Racial and Ethnic Bias in the Courts, and on the board of the Conference of Asian Pacific American Law Professors. She currently serves on the board of the Society of American Law Teachers and chairs its Academic Freedom Committee, as well as serving as the co-director of the Human Rights Research Fund. In her piece, Professor Saito compares the Japanese internment during World War II and the U.S. government's subsequent responses with the treatment of Muslims and Arab Americans and those perceived to be in the wake of 9/11. Professor Peter Danschin attended University of Melbourne as an undergraduate and for law school before entering private practice both in Australia and New York. He clerked for the Chief Justice of the Constitutional Court of South Africa before going on to receive his LLM and JSD from Columbia. He served as lecturer and director of the Human Rights Program at Columbia's School of International and Public Affairs, and he currently teaches at the University of Maryland Law School. He also serves as associate editor of the Muslim World Journal of Human Rights. His scholarship focuses on international law and human rights in the international arena. His article discusses hate speech directed at Muslims or those perceived to be Muslim, as exemplified by the Danish cartoon controversy. He explores the trend of American jurisprudence to favor freedom of speech over freedom of religion. Finally, Professor Gwen Alexis, she completed her undergraduate studies at the University of Southern California. She has a JD from Harvard Law School and a doctorate degree in sociology and historical studies. She has a wide variety of academic experience, including teaching currently at the Business School at Monmouth University. She's also taught law at Suffolk University Law School and teaching in Drew University's Sociology Department. Professor Alexis worked as a practicing lawyer for the U.S. State Department, the Securities and Exchange Commission, AT&T, the New Jersey Supreme Court, and as a solo practitioner. Her scholarship focuses on corporate legal issues and issues involving cultural and religious diversity. In her article, she argues that non-Christians warrant special legal protection in the workplace to ensure that religious freedoms are not subsumed in our predominantly Christian culture. Finally, our moderator is Professor Guy Charles. Professor Charles teaches here at Duke, and he is the founding director of the Duke Law Center on Law, Race, and Politics. He is an expert and frequent public commentator on constitutional law, politics, and race. He received his JD from the University of Michigan Law School and clerked on the Sixth Circuit. Before joining Duke Law's faculty, he previously taught and served as interim co-dean at the University of Minnesota Law School, and I know from personal comments that he's a great inspiration here to the students. So, thank you.
Professor Alexis?
Okay. I couldn't figure how to summarize my paper without PowerPoints quickly, so that's why we're being faced with this. So it's not Christian, but otherwise qualified religious diversity in the workplace. And I actually am making 3 claims, and I think it's important to start out with that, 3 claims in the paper. One is that I'm saying that the much talked about secularism in American society is actually a secularized Christianity, that we've done it, our laws, our institutions are embedded with Christian norms and values that has actually escaped notice until we have been faced with a critical mass of non-Christian immigrants. And this has happened since 1965 when the immigration laws became much more liberal, or I should say less discriminatory, against Asian immigrants. And so that we've actually, for the first time, gotten to where we have deep diversity, where it's not just a matter of us being tolerant of different versions of different sects of Christianity, but that we're actually being faced with non-Christians and also with secularists, human secularists who are not who are neither Christian nor non-Christian, but ethicists, really, normative ethicists. Now. The second claim that I'm making outside of this is that there are a lot of assumptions that go along with being a basically Christian nation. And this is not, even though I'm talking in this paper about the U.S., this is something that is generally found in most immigrant host countries. Most immigrant, I really say all immigrant host countries are basically Christian countries, and so that we find in Europe. And in fact, I did my doctoral studies in Sweden, where there's been an influx of Muslims, and so they've had to deal with the fact that a lot of their laws, which are supposedly secular, have made it easy, for instance, with our Sunday closing laws and so forth, made it easy to fit our culture and our religious beliefs into what we call a secular neutrality. And so I'm saying that this embedment has the worst part of it being that religion should be privatized, that we have this dualistic view of a sacred and a secular, two kingdoms. And I point out that this comes from a Protestant heritage, and Luther and his two kingdoms of the sacred and the secular. But what it amounts to is that we have a feeling that religion should be taken care of on the weekend. It should not be part of our everyday life. Okay, and so that part of our Protestant heritage, I say, is really one of the most insidious parts. There are many others, and I go into some in the paper, but I think that claim is one that I want to put forward as being basic in this, the fact that religion ought to be private. It ought not to be part of the public square. Okay, and then a third claim that I make in this paper, and this one is really central and important to the whole paper, and my emphasis on workplace, the disparate impact of this secular or this pseudo-secularism on the workplace is that the workplace and the educational system, and you can tell this is the sociology coming in here, my sociological background. But those two institutions, the educational institution and the workplace, are really critical in terms of integrating immigrants into the mainstream. Okay? And so that to the extent that those institutions are permeated with Christian norms, then there is a stacked deck against non-Christian immigrants actually becoming upwardly mobile. And so I give an example here, and I feel sort of hesitant to portray this as being strictly American, because I found exactly the same thing with my field studies in Sweden. But in the U.S., for instance, the quality of school that your children attend depends on the neighborhood that you live in. Okay, and it's in New Jersey. There's been a lot of attempts to change our system so that property taxes do not determine how much schools are funded for, because we have areas like Newark, Camden, New Jersey, where children have no computers in the school because they live in areas where they're only renters. They're not properties that are paying taxes, which is the money that's used to fund the schools. And so what happens then is if you're in a poor neighborhood, your children will be attending schools that virtually assure that they're going to be back, that they will not have a head start on education, and in fact, that they start out with the odds being against them ever getting a good education. And so what determines whether or not you can move in a good neighborhood, of course, is the income that's coming into the family. And to the extent that there's employment discrimination, which keeps the family wage earners from getting decent jobs, from being either underemployed or not employed, then we know where they're going to be located in inner city neighborhoods. And so it's like a vicious cycle. Okay. So that I feel that focusing on the workplace and the employment issues really gets to the center of this, because it determines whether or not there's going to be a permanent underclass, a new underclass coming from the new immigrants. Now, I wanted to say also that there is a reason that the U.S. and the U.S. probably more than the other Western European countries has tried to aggressively secularize the workplace. And that's because there are representatives of so many different religions that the workplace needs to be secular territory in order to not result in an inharmonious workplace where everyone is advancing their own religious views. So that to the extent that you can keep religion out of the workplace, then you actually eliminate some of the problems that would result from hearing all of the different views of the sacred expressed. And of course, that goes to the problem with the new immigrants, the post-1965 immigrants, who have these visible religiosity, that you can look at them. It's just as it was with blacks and their integration into America. You visually see the difference, okay? It was not like Italians who might determine to pass for white Christian Americans or Jews who had that opportunity. But we have with this new crop of immigrants, visibly religious immigrants, and readily identifiable. Now, it was interesting that I think it's going to come up in one of the later papers, that Americans tend to favor talking about freedom of speech as opposed to freedom of religion. And in fact, just last week, I had this problem with an article that was coming out in one of our journals for the New Jersey Bar Foundation, where it was saying, well, even though you're free to express yourself at work, you may not be able to come with headscarves and stuff like that. And then, so it was being approached from the standpoint of freedom of expression, okay, as opposed to freedom of religion. And the point I want to make here is that there's a difference between wearing a Christian cross to work or to school. For instance, my son is a Christian and he wears a cross. He's very into the fact. But that is not required by Christianity. Okay? So that's different. For him, it really is a form of expression. Whereas here we're talking about something more substantive. We're talking about practicing one's religion. Beards, uncut hair for Sikhs, males, wearing a hijab or a yarmulke for a Jewish. This is a theological dictate. Special dietary dictates also are the same. And so this quote I like so much from a Muslim. For most Muslims, Islam is a comprehensive system of life. It does not divide the world artificially and arbitrarily into sacred and profane, religious or secular. In Islam, all aspects of life are in one organic unity that coheres into an undifferentiated social and political unity. And that is quite true of some of the other Eastern religions also. So it's like a cultural clash, okay? Not easily separated. And so when you start out with this, we're talking about practicing one's religion by observing these. It's quite different from just a religious expression. And so we are talking about freedom of religion. And Title VII, I mentioned here, of the Civil Rights Act, actually makes discrimination illegal. And so that, and it's important to note that we have Supreme Court precedent for this, not just overt discrimination, but also it prescribes practices that are fair in form and uniform, for instance, secular workplaces, but discriminatory in operation. And so what my paper does is argues for actually using this, building on this past Supreme Court case and looking to the EEOC, which is very good at developing the law in this area, to take note of the disparate impact of coerced secularity in the workplace on non-Christian employees, okay? So that instead of the accommodation language that we're used to and whether or not it's a hardship for the employer to accommodate, I'm saying shift the focus from the hardship on the employer to the rights of the non-Christian employee, okay? The fundamental right to religious liberty. So I'm arguing really for the strict scrutiny judicial review, and that in standards where we find an employer has denied a religious accommodation made by a Muslim, then, and I say Muslims in particular for this because of the pariah status that they have after 9/11. And so I'm arguing that merits making them a protected group. Now, another point that I make in this portion of the paper, which to me is very important as an advocate of civil society, is I point out the fact that thick religious communities can provide social capital that racial and ethnic minorities are otherwise denied in the U.S. In fact, I look at the history of the Jews and blacks and say that Muslims will need to rely on their institutions as the same kind of mediating structures to help them mainstream into U.S. society. Now, this morning we were talking about whether or not Muslim organizations should be the center of this activity, or whether Muslims should gather around their religious institutes for that purpose. What I'm saying here is that the religious institutions should actually become activists for Muslim causes. And so, and I give an example of this with the recent case of Webb versus City of Philadelphia. This was the case where the Muslim policewoman was refused the right to wear her hijab. And I think she only wanted to wear it during special Muslim holidays. But in that lawsuit, which is going to be appealed, she lost because of the City of Philadelphia made a uniformity argument that it was advantageous for them to be able to insist that everyone look alike. That, incidentally, I give the example also. In Los Angeles, the police force has Sikh policemen, and they're allowed to wear their turbans underneath the police hats. But in that case, you see, along with the ACLU, you see 8 Muslim-affiliated organizations filing Friends of the Court briefs. And that's the kind of activism that's going to be necessary on the part of Muslim organizations. And this despite the 501c3 prohibitions on political activity, which, of course, black churches have ignored since the beginning. Now, part 2 of the paper then just briefly makes the argument that at any rate, church-state separation is a myth in the U.S. And I point out the fact, and this is more also to the secularization of Christianity, the secularization of the Christian calendar, that we have Sunday closing laws, we have Christmas as a national holiday. I mean, that's the holiest day on the Christian calendar, say Easter, but it's a national holiday. We have also the civil religion, which is everywhere evident. And Bob Wethnaw over at Princeton gives this definition. Civil religion, the use of God language with reference to the nation, the symbolism by which a people interprets its historical existence in light of a transcendent reality. So, and here we see the National Day of Prayer, "In God We Trust" as our motto, and we see President Obama there with his national prayer breakfast that he just had. And then finally, we have this, the charitable choice initiatives. And we're now in the 3rd generation of faith-based initiatives, starting with Clinton and charitable choice, with this outsourcing of social services delivery from the state agencies to the church. Bush, compassionate conservatism, where he actually opened a White House Office of Faith-Based Initiatives, and Obama with the White House Council for Faith-Based and Neighborhood Partnerships that is now in existence. Okay, I'm just under.
Thank you, Professor Alexis. I'm known as a fierce moderator. Professor Saito.
All right, you might have to remind me. I'm not sure I've got this so well timed.
I'm ready.
Okay. Well, it's a real pleasure to be here. Thank you, and thanks to Lauren, who's been working with our panel, and all of the journal staff. I know y'all, it's a lot of work to put on an event like this, and it's an honor to participate. It's been particularly fun to participate in this because it's been a day, I think, where we've addressed issues on a number of different levels, including at very human levels. And a lot of times academic conferences tend to make everything abstract in a way that is fine, but you sort of file it away and never think about it again. I think that y'all have done a great job of combining the different levels of approach. I wanted to start by just noting and also somewhat being appreciative of the fact that we're here on this land. And usually wherever I go, I try to find out whose land it is, really, besides Duke. And it's a little bit hard here, possibly because I haven't done enough research, but it's also hard because the histories have been obscured. But, I think we know that the Cherokee Nation came over to a little bit east of here. There's Tuscaroras, who are part of the Iroquois Confederacy, who are in this area, Lumbees, Chirop descended people. A little bit east of here, I've seen that there's groups known as the Ino and Sissipaha and Kiowa that were in this area. So it's not clear to me exactly whose ancestral lands we're on, but I think we need to pay attention to that. I think it's important to always pay attention to that wherever we are. Because for me anyway, it helps me try to stay grounded in a reality of appreciating the many layers of history that have gone on in any place, of being grounded actually where we are, especially for those of us who ride a lot of airplanes. That's really important to staying sane. And to not allow ourselves to be in denial about the realities of our present situation. And I would like to translate that attempt to not allow us to, in our minds, be in denial any more than sort of psychologically necessary, into this talk, and in talking here about law, because I'm really happy that we haven't only been talking about law in this law school context. But I think law is also very important to the issues that we've been talking about. And I want to talk about I presume, how many of y'all are law students? Okay, pretty good crowd. I presume that we all come to this with the belief that the rule of law is important, that, compliance with the rule of law and with our most fundamental basic presumptions is really significant. A lot of what we've heard today is this or that doesn't comport. It's not really American in the best sense of American. It doesn't comport with our values. And I think we trace those values, at least in some part, to being rooted in the Constitution and the Constitution's guarantees of equality, freedom of speech, opinion, religion, etc. And, probably all of us would write the Constitution a little bit differently if we got to do it all on our own. But it's a very, I think it's a real good starting place, and I'd be real happy if we could get compliance with the Constitution. But I think as we look at these things, we need to look at how we frame this from a legal perspective. And of course, I know y'all have all read Marbury versus Madison, right? This is a government of laws, not of men, and the sort of concomitant principle that where there's a legal wrong, or if we're going to rectify a legal wrong, there has to be a legal remedy, that without remedies, you don't really have a viable system of law. And so I want to sort of frame my few minutes here in that context. And I think the whose land is this premise is important to start with, because if y'all have talked about the Marshall cases in your property classes, right? That's one of the foundational things, the Marshall cases that had to do with who had underlying rights to Cherokee land in North Georgia, right? If you actually read those cases, maybe not just the excerpts that are in your textbooks, you'll see that Justice Marshall goes through the arguments for why it's okay for the settlers to take this land. And it comes down to, because the people who lived here, or were living then, completely counterfactual assertions about they're savages, they're roaming, they have no government, they have no communities, they don't cultivate the land, et cetera, et cetera. Absolutely counterfactual, right? But he had to go there to those stereotypes in order to justify the occupation of the land. And he even acknowledges that. He says, well, to some people, I'm obviously paraphrasing, to some people, this might seem like it's not really doesn't really comport with the law of nations, i.e. international law, or maybe, our own law here. But hey, we are, quote unquote, the courts of the conqueror, and therefore we have to enforce the will of the conqueror. Now, to me, that's extremely significant, because it means at the most basic level of the legitimacy of the legal foundations of this country that we're talking about here, defending and protecting and being inclusive of, is based on an acknowledgement that to justify this action, we had to invoke irrational stereotypes, and then we had to invoke a resort to power as opposed to law. And I think if you go back and look at each of the legal decisions that underpin what is happening today to Muslims and Arab Americans and people perceived as same, you see a resort to this type of logic and to these types of cases. And that's why I think looking at this history, looking at this law, looking at it not in some kind of glossed over abstractedness, but really concretely, realistically, is very important, because that is what will allow us to utilize the law to counter contemporary trends. For example, in the Guantanamo detentions and in the roundups of Muslims and Arab Americans, et cetera, after 9/11, government lawyers were explicitly arguing to the Chinese exclusion cases, right? And the Chinese exclusion cases, in turn, were based on all of these kinds of irrational stereotypes about the yellow peril, et cetera, et cetera. So if the actions that we're trying to challenge today are justified by a law, which in turn rests on foundations of irrational stereotypes, by unpacking those, we can prevent that same kind of stereotype from being invoked in order to say, well, I know it's a little harsh, but it's the law, right? So with that as sort of background, I just wanted to say real briefly, Try to be real brief. I think when you look at a wrong historically, you have to look at what is actually the real nature of the wrong and what is a remedy that would actually redress it. And actually redress it both in terms of what is necessary to come as close as you can to make somebody, some people, some whatever situation right, and also to deter future conduct. And that's the lens through which I try to look at the Japanese American internment to assess what's happening now and to try to sort of get some useful understanding of what we can do now, learning from that history. My father's family was interned during World War II, and so I grew up hearing a lot about that particular situation, and so that's, I'm sure that's part of why it sort of informed my take on a lot of other things. But I've been sort of surprised at ways in which I think that the internment story is misused. In defining what was wrong, one of the things that we heard after 9/11, right, immediately after 9/11, are we going to have that kind of situation again? Are Arab Americans or Muslims or, some identifiable sector of people that were associated with the attacks of 9/11 going to be rounded up en masse and incarcerated? And people have drawn parallels, which I hope to draw a few of here. But by and large, the feeling of sort of civil libertarian types has been, whew, we dodged that bullet, right? There's some bad stuff out there, right? But we didn't go as far as we did in World War II, and therefore things must be getting a little better anyway. You'll probably be really shocked to find out I don't really take that position. But I think part of that all depends on how you define what was wrong. If what was wrong was you came up with essentially a blood quantum, a genetic analysis of who the enemy is, and then rounded up everybody who is of that genetic line and put them, men, women, children, old people, babies, in a camp in the desert for 4 years. No, we didn't do that, right? If that was the wrong, that has not been repeated. Does that mean how much time I have left? Okay, good. One of my favorite analyses, I think, to me, one of the best analyses of the internment was written in 1945, right just after the Korematsu and Endo cases were decided. Do y'all still read Korematsu and con law? Okay, so you're kind of familiar, right? That's the case where the Supreme Court said about the Japanese American internment, well, it doesn't look real good, but the government tells us that it's military necessity that we do this. Well, first of all, they pretend like they're not talking about the internment. They pretend like they're just talking initially about the evacuation from the West Coast, right? And then they say, the government, the military said we had to do it, so we have to believe them because this is a matter of national security, essentially. Professor Eugene Rostow, who was a Yale law professor then, and, not a flaming radical or anything, this was what he said was he issued what I think is still the best analysis of the 4 internment cases that came up to the Supreme Court in 1943 and 44. And he said, these cases set an extremely dangerous precedent because they have said it is okay to do these following 5 things. And I just want to tell you what Rostow's 5 things were. He said, under this precedent of Korematsu, number 1, it's a protective custody extending over 3 or 4 years is a permitted form of imprisonment in the United States. Okay, protective custody as opposed to being convicted for a crime and then incarcerated. 2, political opinions, not criminal acts, may contain enough clear and present danger to justify such imprisonment. In other words, you can be imprisoned for your ideas, right? Men, women, number 3, men, women, and children of a given ethnic group, both Americans and resident aliens, can be presumed to possess the kind of dangerous ideas which require their imprisonment. Number 4, in times of war or emergency, the military, perhaps without even the concurrence of the legislature, can determine which opinions require imprisonment and which ethnic groups are infected with them. And number 5, this decision can be carried out without any of the protections of the Bill of Rights. That's how Rostow defined the dangers of the internment. So that's sort of the lens that I look at to see what's been happening since 9/11. Looked at it from that perspective, I think that we have lots of the same problems, right? This precedent has in fact been acted out. We have had detentions without constitutional protections, the protections of the Constitution. I think our lunchtime speakers spoke about some of those in terms of rounding up people, in terms of preventive detention or detention without trial. We certainly know that that's been true with respect to people, non-U.S. citizens arrested elsewhere, but also at least with respect to Jose Padilla and Yasser Hamdi, who were U.S. citizens. And, we can say, okay, that's just a couple of people. It doesn't make me feel a lot better to have internment camps of 1 as opposed to 120,000. It also doesn't make me feel a lot better that, the rationale was sort of, well, it's only, some of the laws that were passed, like the Military Tribunals Act, only apply to non-U.S. citizens. The problem is the provisions, there's a lot of problems, right? One of the problems, though, in taking any comfort from that as U.S. citizens is that the provisions of the Bill of Rights that are at issue here, 4th, 5th, 6th Amendment ones particularly, 8th Amendment, don't say U.S. citizens. They say all persons. And so if they can be violated with respect to, permanent residents or green card holders or anybody, right, that means they can just as easily be violated with respect to citizens. So I don't think anybody should feel real good about that. We have had You're supposed to give me like a 2-minute warning. 1 minute he says 7 minutes left. Oh, did that mean, was that a 1?
That was a 7.
That was a 7. Okay. I'm taking 1 minute more. Okay. I think that if we look at it, we'll see that we have detentions without constitutional protections. We have imprisonment for presumed political belief. We have ethnicity or race, religion, some variant of that being then imposed as a proxy for having that kind of opinion, which is then correlated to that kind of criminal activity. And we have a huge expansion of executive power to implement that framework. The Obama administration has retracted some of the executive orders of the Bush administration, but they haven't done it on the basis that that was not legitimate executive power. They've said, we have this executive power and we change, and we use it to change our mind, not to say that was an illegitimate use of executive power. And so I think that the remedies that we got, significant remedies, redress in terms of Japanese American internment, an apology from Congress, money for surviving internees, a public education fund. Supposedly this was recognized as a wrong, acknowledged to be a wrong, redress officially voted by Congress, right? That's very significant, but it didn't change the underlying situation. And one of the reasons, I think, there's 2 reasons, and I'll shut up. I don't think it changed the underlying situation. One is that I don't think it was actually redress and reparations for the wrong. If you look at what was being said in Congress when the Civil Liberties Act, which provided this redress, was passed, it was, oh, these Japanese Americans were so good and so loyal, they just went along with the program, they cooperated so well, they sent their kids off to fight in the military from these concentration camps, we should reward them, right? The people who saw that it was wrong and who resisted, still to this day, are not honored. And if you're not honoring the people who resist the wrong, you're honoring the ones who go along with the wrong, that sets a very different precedent. Number 2, the actual people, if it was a wrong, and there's lots of documentation of the wrongness and who was responsible for that wrongness, none of those people actually were held accountable. In fact, they were all promoted, given cushier jobs, better standing, etc. If we do that, which I think we're also doing now, right now, we're not going to prosecute people. We're going to look forward, not backward. We're not holding anybody in government accountable for the wrongs that have been happening over the past 10 years. And I think as long as we do that, it doesn't matter what we say about what's wrong or right, legal or illegal. If the message is you go along with the program and you implement illegal and unconstitutional programs, life will be good for you, right? that's the incentive structure that's in place, and that's the result we're going to get. Thank you.
Thank you very much. Well, first, let me please just thank the journal members, Stephanie, Lauren, Shelley, and Matt for looking after all of us, I think, so warmly and graciously over the last day. I'm delighted to be part of this conversation, and much of what I'm going to say is actually going to build, I hope, on the points that are already have been made here. I think earlier Aziz stated our theme actually pretty well. The symposium, as I understand it, is trying to chart what has been called the new face of discrimination and to assess legal responses to that. Now, let me just say up front, perhaps this goes without saying, this is challenging. There is some very difficult theoretical and conceptual work that needs to be done in this area, and what I'm going to present is by far from a fully thought through or complete thesis. But what I'm going to try to suggest is some of the ideas that we need to confront to really start to grapple with what's at stake in this area. And in that sense, I really appreciated Professor Alexis' comments before. As Aziz said, how does the state imagine the problem? What is the epistemology of our legal categories? And how do ideas about religion, very intuitive and deeply culturally and historically grounded ideas about religion, enter into our understanding of our law and our most cherished law, right? And here, much of what I'm going to say is about the First Amendment itself. Now, let me just say as well, I come at this as a kind of inside-outsider. I'm not American, but I've lived in this country for 15 years, and so I have that kind of very strange status of an inside-outsider, which is both helpful and difficult at times. I also come at this problem as an international lawyer. And I think international law, particularly human rights law, helps us to see, sort of provides a critical mirror by which we can start to see some of the silences and assumptions in American jurisprudence. Now, one of the difficulties is how does one start this conversation without turning off an American audience or students or scholars grounded in this tradition? When I've presented these ideas to my own faculty, they've said, Peter, what you're suggesting is effectively heresy in America. And I replied to that was the greatest compliment I've been paid, because it confirms something that I intuitively suspect, which is that much of what passes as thinking about the First Amendment is a kind of religion, a set of beliefs, a set of convictions that are adhered to despite rational and reasoned argument to the contrary. So how does one start to undermine or to make people question their secular religion? And I think that's what this question about Islam and Islamic norms is forcing us to do in quite interesting and I think very confronting ways. And what I think what happens is if we confront these questions openly and seriously, we start to see that our categories and thinking on these questions are deeply historically and culturally determined. That's my thesis in any case. Well, for me, the Danish cartoon controversy provided a wonderful vantage point by which to think about this problem. Of course, for those of you who may not be familiar, the cartoons were published in Denmark. One of the cartoons depicted the Prophet Muhammad as a suicide bomber. And this set off violent and very heated protests both in Europe and across the Islamic world. And there have been a number of reactions to the cartoons, and let me just chart three very quickly. One story that's been told is that the cartoons depict something like the incommensurable divide between the liberal value of free speech and a religious taboo, in this case the taboo against blasphemy, which mysteriously and wonderfully the modern democracies of the world have managed to transcend, but which Muslims and others are still somehow committed to. Another story, a second story, is that this is really about the place of Muslim minorities in the European nation state. And here the story is constructed as the West, on the one hand, as defined by democracy, secularism, liberty, and reason, confronting, on the other hand, a group of people adhering to a religion, Islam, which is defined by tyranny, authority and unreason. And we see that kind of debate playing out in some very difficult ways, particularly in Europe today. And people are familiar with the minaret controversy and proposals now in France to ban the burqa from various parts of the public sphere. A third story that gets told is that this is really part of a broader phenomenon of Islamophobia and discrimination against Muslims in the post-9/11 world. And much of what we've talked about today, I think, fits into that kind of narrative. And the question then becomes, what is the relationship between speech, extreme or hate speech, and discrimination? And should the law have something to say about that difficult category, that difficult normative category, which doesn't correspond to our notions of discrimination in the sense of workplace discrimination or conduct, but at the other hand, is in the sphere of speech that seems to rise to a level that attacks a group of people for certain ascriptive characteristics. Well, each of these narratives captures something about what's at stake, I think. And what my interest has been in my paper for this symposium is how, as a matter of law, a liberal democracy should respond to manifestations of this kind of incitement to what international law calls incitement to religious hatred. Okay, so that's my question. Now, to me, what's most interesting about this is not what it says so much about Islam or Islamic law, but what it says about our own histories and our own understanding of liberal political orders. And what drove me to ask these questions was the incomprehensibility, it seemed, for all of us, or some of us, perhaps all of us, to understand the type of harm that seemed to be expressed, the type of deep sense of injury that many Muslims expressed that was caused by the publication of the cartoons. And my question was, is this type of religious pain even intelligible within our liberal calculus of individual rights of speech and religion? Or is this kind of pain simply rendered mute by the way our law is currently constructed? So my title is provocative. My title is Defaming Muhammad. Actually, our lunchtime speaker referred to a case about a person called Muhammad, in this case, the Prophet Muhammad. Now, what I find suggestive about this is some kind of intermediate position assumed by something like the Prophet Muhammad between Islam as a religion on the one hand, the notion of defaming a religion, which some states around the world are now calling for international laws dealing with the defamation of religion. I think that raises different questions which I'm not going to address, and I think there's perhaps less, I would support that kind of movement, I think less, for reasons I get to in my paper. So on the one hand, one has the idea of defaming Islam. On the other hand, one has the idea of defaming Muslims. And what I try to address in the paper is the notion of defaming a person as a Muslim and how that might correlate with ideas about hate speech and about human dignity, which, for example, Jeremy Waldron has recently addressed in his Holmes lectures at Harvard, and I'll say a word about that in a moment. But situated between these two positions is the notion of defaming the Prophet. What does that mean? And what I suggest in my paper is that this idea only becomes intelligible once we start to gain some understanding of the relationship of intimacy that Muslims have with the Prophet. And the idea of Muhammad as an object of veneration and emulation, a sense of embodied habitation and intimate proximity within the practice of Islam, as opposed to the worship of the Prophet as an abstract idea. The idea, as Professor Alexis put it, of Islam as a practiced religion, a way of life that is comprehensively lived and imbues everyday ways of life, of embodied practices and of virtues that shape meaning and modes of acquisition of both devotion and piety. Once we think about a religion in this sense, once this idea of a religion becomes more visible, of an embodied set of practices and a living nature of effective relationships, in this case, say, between Muslims and the Prophet, the notion of moral injury that is caused by denigratory and aggressively, purposefully hateful speech, I think starts to gain a little more salience in our understanding of what's going on here. And we can no longer simply calmly assert that the right to freedom of religion in this case is not at issue in this controversy. So this is what my paper pursues. This is the question I open up. How is it, under the First Amendment, that we understand the relationship between free speech and freedom of religion, effectively? And in most of the legal commentary on the cartoon controversy, we see the idea not framed as a conflict between rights, but rather a conflict between free speech on the one hand and blasphemy on the other, as some kind of religious taboo or oppressive restraint that we have transcended in our modern liberal democratic order. So the question I ask is, why do we construct the question in this way? Why do we apply the Brandenburg versus Ohio test as suppressing speech only if it rises to the notion of imminent violence, as opposed to understanding it more in the international human rights sense of speech that incites hostility, violence, or discrimination against a group of persons because of, in this case, their religion? Now, it may well be that the cartoons do not meet even the international law standard, and that would be an interesting discussion to have. But I think, as Waldron and others have argued, once we understand the values that are at stake, the harms that are at stake in this kind of visible public manifestations of hatred, we can no longer simply rely on the old verities of Brandenburg versus Ohio. That's one argument. My second argument is far more difficult to make in 2 minutes, but it goes something like this: that what is happening in our understanding of freedom of religion is that we are assuming a prior concept of what religion actually is. And I think this was Professor Alexis's point. Religion is something interior to a person. It is something believed as part of one's conscience. It's something deeply private and not necessarily something that is practiced as one's everyday way of life. And this is how the law, I think, understands religious freedom as well, although the American jurisprudence is very subtle and complicated, actually, on this area. And we see struggles within the First Amendment over this question of to what extent the state can limit the actual manifestation of religious belief. And this gives me some hope, actually, in the American context, that these debates can occur as opposed to a country like France, for example, where the discourse seems more closed to that question. So what I ask in my paper is, what happens if, as lawyers and as students, we start our discussion by understanding religion in this more public and more sensitive and more comprehensive sense as a way of life as opposed to a set of beliefs? What if, for example, we see the Sharia as defining a very complex set of legal norms and codes that define notions such as dignity and freedom and equality, not as threats to them? Right? What happens if we take that internal perspective into a very well-established tradition and set of norms? How then do we understand the notion of harm as between speech and religion? What would it mean to take religion in this sense more seriously? Now, interestingly, in the United Kingdom, a debate of this kind is actually going on at the moment, and the United Kingdom has just passed a law that prescribes the advocacy or incitement of religious hatred. And this actually moves the English common law beyond its old notions of blasphemous libel to the prescription of speech that targets any group on the basis of religious belief. So I think in the United States we think of the United Kingdom as a liberal democracy premised on the rule of law. Why is there a different debate going on in England on this question as opposed to in the United States? And that's a question I really try to grapple with in my paper. My final point, and this would take a lot longer to really explore, is that the question I believe before us is not whether we should embrace pluralism within a democracy. One of I think the most impressive things about the United States is its strong embrace of pluralism, and in a sense I see it as an embrace of a liberal form of pluralism. The First Amendment, in that sense, does already embody this notion of toleration and respect for difference. The challenge before us, I believe, is to move beyond these more traditional notions of liberal pluralism to what I call value pluralism, which is to understand a democratic society that embraces different ways of life, different conceptions of what it means to express human freedom. And that really challenges some of our core assumptions about what, for example, the free exercise of religion means. Does it mean, for example, as the Archbishop of Canterbury has suggested, that religious Muslim communities could practice and have as part of their communal life aspects of Islamic law? Should our legal system recognize so-called autonomy regimes which allow for Islamic law within the family or within different spheres of life? Would that be embraced within a broader sense of freedom of religion? And I think that's a tremendously interesting question. I think it's one that is going to cause tremendous political struggles in this country. But I think that is the type of question we should be thinking about. Thank you.
Excellent. So the job of the moderator is to keep the time, and if you've done that well, you get to ask a question. I have kept the time. All right, so one question, and then we'll open it up to the audience, but one question for all of you, and actually it picks up precisely, I think, from your last points, Peter, but as a theme that I think runs through all of the panelists, and that seems to me to be a faith in law, not surprising from some well-trained lawyers, but a faith in law, but a clash between law and culture. All right, so part of the question, so you asked the question, why is it that England is different from, say, the United States? And one of the question that I have for all three of you is how do you reconcile this concept that the law reflects the underlying cultural struggles versus what I think seems to be more of a positive frame from each of your presentations, that the law ought to lead the culture, that the law ought to change how we think about internment and say profiling of Muslims, that the law, that we can make legal changes to freedom of religion, for example, by saying, okay, maybe for certain practices Muslims are a protected class and ought to have a certain type of religious identity reflected, say, in the workplace, or that we ought to take, for example, the more provocative frame of your thesis, Sharia law, as part of our understanding of what the First Amendment means with respect to toleration, et cetera. But that assumes, it seems to me, that there's some work within the culture, a conversation, to again use a term that has been used, that has already taken place, but which in fact it doesn't seem to be so, at least not in the American context, as we're debating today. So it seems to me that there's some, perhaps maybe tension between the two. If so, how do you think about it, as it seems to be one of the themes that run through all three of your presentations? You might take a brief moment to address that.
I want to address this right away because one of the things that I feel very, very strongly, and it sounds like from your question I didn't get it across, is that our laws really are based upon our culture. Religion is a bearer of culture. Culture is a bearer of religion. And so our laws are embedded with our Christian culture. Okay? And so what I see as happening is that there is a clash of cultures. That is what's occurring, and it's occurring post-1965 when East has met West on Western territory. So that I see not that our laws inherently can address that, because our laws are based upon that. And I teach business ethics, and I say to my students, everything that's illegal is not unethical, and vice versa. But eventually, our ethics become coded law. Okay? And so if we're a society that's based upon Christian ethics and Christian norms, and that's why in no Western countries do you see polygamy as legal. Okay? It's illegal because in the Christian religion, it's illegal. So that I don't really see it being addressed from the law as the law stands now. Okay? I see there has to be changes in the law, and that's where I say this is where civil society comes in. Okay? This is where politicizing, really, our religious institutions, because those are the ones that we have to look to actually carve out space for Islam as an American religion. It's up to them to do it. It won't be done by our laws.
I think that's a great question. And it has a lot of resonance for me because I think that is one of the things that we struggle with in looking at domestic law, in this case generally U.S. law, and the international context and the international human rights law context. And that's one of the reasons I think that distinguishing between the rule of law and how the rule of law in its best sense plays out in different settings and law, you know, as passed by a particular legislature and as enforced by the police, or maybe as not enforced, but, you know, law enforcement, how those concepts have to be disentangled. I also I think that what you're talking about is a real contradiction, and personally I trace that to the belief that we have come to accept that only states as recognized in international law, you know, the grounds of the planet have been divided up like we see on the maps in elementary school into these different colors, and within those boundaries there is one government of the state and blah, 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 right? I think actually in order to properly address this issue, we have to loosen up our notion of what is normally considered state sovereignty. But I do think that in a bigger international law paradigm and human rights law paradigm, which I believe is actually accommodated in the U.S. Constitution, and U.S. law can be, you know, can work cohesively within that framework. But I think that's what the recognition of the right to self-determination is all about, and that's a core fundamental human rights provision. And if we can look at the right to self-determination, and if we can look at what that means playing out in different communities, and if we can get rid of the idea that there is necessarily always one, you know, for the entire state there has to be exactly the same way of interpreting certain rights and responsibilities, you know, we could come out with a much more multi-layered, you know, sort of fitting approach to a lot of these problems that would accomplish the end result of what the rule of law is supposed to accomplish.
That's a terrific question. So many angles on which to respond. I agree with your point that it's a mistake in a sense to juxtapose law with religion in the question, because the two are deeply, law with culture, because the two are deeply entangled in this way that we're trying to address. Let me just make 2 points. This is where I think international law is actually quite helpful. So if you think about the Covenant on Civil and Political Rights, it contains an express provision saying that states are required to prohibit speech that rises to the level of incitement to hostility, discrimination, and violence. Virtually every modern liberal democracy has hate speech laws. The United States stands almost alone.
Pridefully so.
Proudly so, absolutely. And so the notion of exceptionalism I find very interesting here, because the United States is exceptional in its prioritizing of free speech in this sense. But it's also exceptional in a second sense, which is that nobody else agrees. Now that should give us some pause. How is it that everyone else is wrong? Now that
Happens
I think,
all the time.
right? And how is it that they could be so wrong about the thing we prize most? Well, there's something going on there that's actually, I think, quite interesting. And what it suggests is that we need to view fundamental rights like free speech in a more dialogic sense, as opposed to some kind of deontological a priori sense in the way that much of our teaching in this country occurs. Of course, this seems to threaten our notion of rights. in the first place? You know, if rights are really about a dialogue between differently situated actors, then how do they differ from other aspects of our laws? And many scholars are asking that question, right? It does undermine our notion of rights. But I think where that conversation leads us is to a notion about pluralism in the law itself. Not just pluralism in society, but pluralism in the legal system itself. Now, Professor Saito and I were talking this morning. We have an entirely different legal system in the United States in the form of Indian law, as I believe it's called, autonomy regimes of the rights of indigenous persons. And there is some limited recognition of that autonomous sphere. I'm not sure if you would agree with me, but I think that recognition is within our system, but we don't talk about it. Right? We already have plural notions within our law. This shouldn't come as a surprise, I don't think.
Yes.
So I have a question for Peter and for Gwen about lesser evils. And maybe I can start with Peter. So you made an argument on behalf of laws favouring or penalising group libel on the basis of the harm that they cause to members of the group. But I wonder whether a defender of the First Amendment might respond to you that the basis of the prohibition on group libel laws is not so much an assessment of the kind of harm that follows from group libel. It's rather a comparative judgment of the world, or a comparative judgment of what the government does in a world where that prohibition exists versus what the government does in a world where the prohibition doesn't exist. Such that if we have a regime that allows the government to enact group libel laws, what we would expect to see, given the fact of majoritarian democracy, are group libel laws that protect the majority and that burden the minority. And indeed, we might look to other parts of the world. So you mentioned the United Kingdom's recent law. So the first prosecutions by way of that law, first prosecutions under that law, have been prosecutions of members of SVO Korea for protesting the Danish cartoons, right? So the notion that you can have a regime of group libel that protects minorities, right, the people who you would think would be most vulnerable to harm, may be inconsistent with the underlying democratic mechanics of government. And it's the suspicion of those underlying democratic mechanics, right, that a healthy suspicion, I think a Madisonian, or somebody working in the Madisonian tradition would say, that underpins the First Amendment's prohibition on it. So it's not so much a conception of the harm that's driving the prohibition. It's a conception of this is the lesser evil. The greater evil is giving the government this power. And equally, Gwendolyn, I was struck by by your argument that we in the United States erect too high a hurdle to the exercise or the entrance of religious reasons into the public sphere. Now, I don't know whether that's true, but surely part of the motivation there is a reflection upon the experience of other countries that have, in which religious reasons drive the content of law, in which religious reasons drive the regulation of the public sphere, where you have laws such as those in Pakistan, where to say Assalamu alaikum, if you are not a Sunni Muslim in the way that the chaplain did this morning, if you are, for example, a member of the Ahmadi sect, is an act of blasphemy, punishable by death, right? So we might think that this acoustic separation, this effort to keep religion out of the public sphere, is, again, it's not, nobody I think defends it as ideal, but it's a lesser evil in comparison to what happens when we don't keep religion out.
I'd like to respond to that. And first of all, I think I would say that the reason that we actually say to the corporations and to our corporate employees that you should do this unless it's a hardship. this is really self-referential in terms of the U.S., and it's completely economic. When they say a hardship, they mean, is it an economic hardship? So it is not looking beyond our country to see what has happened in other places where you have let religion come in. It is actually spoken really from the standpoint, and those laws are from the standpoint of our own government, lobbyists in our own capital, lobbyists for business, who are really behind this whole position. The main determining factor of whether or not something is a hardship in the workplace is an economic analysis, okay? And this is the way it's defended when corporations come in to say, no, we can't accommodate this. It's entirely on an economic basis. And so to that extent, I think it's relevant to see to what extent do they actually determine whether or not it's a hardship. And it has to do with an underlying feeling that this is not really religion. This is really not practicing religion. This is really not important. And it's spoken from the standpoint of your own religious heritage. So no, there's no doubt in my mind that is, it is not based upon actually having analyzed the bad effects that happen from letting religion take a central part in a culture, in other cultures. Not at all.
Thanks, Aziz, for the question. You raise a good point about the so-called suspicion of democratic majorities. Again, this is, as an inside-outsider, this is a fascinating aspect of the culture in the United States. The government or the state restricts speech on all sorts of grounds already, right? Let me list a few. The First Amendment can be limited in cases of fraud, perjury, obscenity, fighting words, defamation, copyright, patent, commercial speech. We allow democratic majorities to restrict speech in all these areas. Why do we hesitate when it comes to the question of hate speech? Why is the content-based restriction suddenly more pressing in the question of hate speech? And as Jeremy Waldron has pointed out, this is particularly interesting given that this is the one area where majorities act to protect minorities. Right? This is the one case where in fact the laws are passed with the express purpose of protecting those who may be vulnerable to attack and may not be able to defend themselves in a democracy. So it's a fascinating question. It's particularly fascinating to me because one of the striking things in the post-9/11 context, to me, is how easily and quickly Americans have deferred to the government in all sorts of areas, particularly in the security areas, right? So policies of racial profiling, detention, wiretapping, a whole array of areas where I have great nervousness about the role of the state. The majority seems quite comfortable. But if the majority acts to protect a minority, a vulnerable minority, from speech that rises to vitriol and hatred, we say that minority must bear that cost because we're nervous about the government restricting speech. It's fascinating to me. Yeah.
I just wanted to add one small story that I think really backs up your point. We were part of protests of Columbus Day that were organized by the American Indian Community in alliance with about 80 other organizations in Denver for many years. And the whole purpose was the hatefulness of the sort of conquest mentality that was being put forward in those parades and the damage that was doing, especially to young Indian kids, et cetera. And so 2004, 244 of us got arrested. And 7 of us were sort of in the show trial that kicked off first. And our arguments went to equal protection. They went to the Convention on Genocide that the United States has ratified, the Covenant on Civil and Political Rights, that provision that you talked about, a number of other international human rights law instruments, the Constitution's protection of, recognition of treaties and international law and human rights, et cetera, et cetera. And the states and the city governments argument was they were protecting the First Amendment rights of the parade. The judge literally told us that our lawyers in our closing arguments, the city could argue First Amendment. Literally, we were not allowed to use the words, much less the concepts, international law, genocide, or constitution or constitutional. They could talk First Amendment. We couldn't even say this is unconstitutional, right? So, I mean, it's like, make your point about the First Amendment trumping.
Absolutely. And I agree with you that the question of differential enforcement of the laws is going to be a problem, obviously, yeah.
By the way, we still got acquitted by the jury.
That's why you're here today, huh?
Following up on Aziz's point, but maybe a little bit off, but this goes to Peter. Actually, if I had enough time, I could come up with questions for all three of you. But Peter, I'm wondering if part of the explanation of the difference between the United States and the United Kingdom is that, and other Western countries, is that we're far more libertarian, and I mean small L libertarian, in our culture than the rest of the world, or certainly Western Europe. And so the examples you gave where we limit First Amendment protection, all the falsity type crimes, well, the idea is that a knowing falsehood is not protected, and shouting fire in a crowded theater, incitement, these are ones where the law recognizes an actual demonstrable harm.
Yeah.
Hate speech, on the other hand, is offensive, it's obnoxious, but our view is that I'm offended is not the kind of harm we're prepared to recognize because of the libertarian sort of value. And if we did recognize I'm offended because I'm X race or I'm Y religion, it seems to me we get some pretty bad results in the sense that I've never quite understood the basis of the religious argument against gay marriage. I understand the sincerity of it, and the people that I've talked to, it seems very sincere. It seems that it's not based on any sort of intentional animus. It's based on this really devout belief that their marriages will be harmed. Personally, I don't understand the nature of that harm, of how my marriage would be harmed by allowing gay marriage. And in the same way, I think that my inability to understand the harm that devout Christians state about gay marriage is analogous to how Western society has trouble understanding the harm that devout Muslims feel about the cartoons. Mm-hmm. But if we go down that route, then it seems to me that your analysis, I would ask you, how would you deal with the question of gay marriage? Would a religious group be able to say it offends us and our free exercise rights are thereby diminished because we have to put up with this harm in society that you're inflicting if you want to start recognizing gay marriage? Mm-hmm. Because it seems to me that the American libertarianism would say it's one thing if you want to exercise your religion as you are, and I think therefore Gwen's arguments are more likely to carry weight for somebody to say I should be allowed to wear a scarf or burqa or whatever, because if you can do your job dressed however you want, you should be allowed to dress that way. Whereas what you're arguing is very provocative, but starts to get into the realm of using religion to tell other people what they can or cannot do.
Right. Well, let me change the question slightly, not because I want to avoid it.
But that's a good way to do it.
Although, yeah, as I
You have 2 minutes.
as I teach my students, the best way to answer a question is to change it to one you want to answer.
Yeah.
But I don't want to do that here because it's a terrific question and it's one I'm grappling with. And I think two responses. One is it would at least require us to inquire seriously why many religious groups have difficulty with gay marriage. To take that seriously, to try to understand the sense of harm. And I think when one enters into that dialogue, it does complicate the discussion, even if one is, in say, in my case, a proponent of same-sex marriage. I can get an appreciation of someone who disagrees with me. And that may require some accommodation, as we see in America today. Right? We see some quite complex forms of accommodation being struck on this issue. But let me flip it a little, because I think this helps to see it more clearly. What about polygamous marriage, as Professor Alexis raised? Right, I'm in favor of both same-sex marriage and polygamy. Are you with me on both?
If I have time, I'll answer that.
Right.
You each have 30 seconds.
I guess the point I'm making is that our discomfort with the restriction on same-sex marriage is that it offends our liberal instincts. But polygamy in a sense, also offends our liberal instincts. So if I'm consistent about it being a value pluralist, I have to take both seriously. And when I look at it, I think an argument can be made that for polygamous marriage, the president of South Africa, Jacob Zuma, has 20 wives.
Is that an argument in favor or against?
Well, the point I make is that this is a question in other parts of the world that is very much alive. And I'm sure many will disagree with me about polygamy, as they would about same-sex marriage. But in each case, you know, we could keep the game going, arranged marriages, and so on and so forth. I think the questions are not easily resolvable, and that there has to be a dialogic engagement with the question.
Please join me in thanking our three amazing.
Perfect.
It's funny because I always get that question.
You do?
Yeah, the gay marriage question. Yeah, it's in.
Good afternoon, everyone. We're going to move right into our closing remarks so that we can all get to our reception outside after we're done. My name is Jillian Harrison. I'm the internal managing editor of the forum. Before I introduce our final speaker for his closing remarks, I just want to make sure to let you all know about the reception immediately following the remarks just outside this classroom where we had lunch. I would also like to extend some thank yous to some people who are crucial to making this symposium happen today. The forum would like to thank our advisors, Professors Neil Vidmar and Brock Richmond, for their advice and support. We'd like to thank all of our panelists and speakers for joining us here today and contributing their scholarship and enthusiasm. I also want to express our appreciation to our moderators and our co-sponsors, Student Organization for Legal Issues in the Middle East and North Africa, the Women Law Students Association, Duke Bar Association, and the Duke University Muslim Students Association. The executive board would also like to thank our entire staff, especially the symposium committee and external managing editor Stephanie Lamb for their tireless work over the last few months to make this symposium our most successful event to date. And I'd also like to thank all of you for joining us in this very important dialogue. It's heartening to see so many of us are interested in finding solutions to this problem. Now, it is my great pleasure to introduce to you our final speaker of the day, North Carolina Senator Larry Shaw, who's generously agreed to share some closing remarks with us. Senator Shaw is currently serving his sixth term in the North Carolina State Senate. His political career includes serving in the North Carolina House of Representatives from 1995 to 1996 and the North Carolina Senate from 1997 to the present. A native of High Point, North Carolina, Senator Shaw attended Alabama State University, where he earned his BS and master's degrees. He's the founder and chairman of Shaw Food Services, the chairman of the Council for American Islamic Relations, and is the founder and former chairman of the North Carolina Minority Business Association, as well as a member of a wide variety of other civic and business organizations. We are very grateful to Senator Shaw for joining us today and for closing out our symposium with his remarks. Please join me in welcoming Senator Larry Shaw.
Does someone leave a timer up here? Good afternoon, ladies and gentlemen, men and women. I think I saw a show of hands of there were students, and I'm really encouraged on a Friday afternoon to see so many students here. I tell you, it's been a wonderful symposium. I have certainly enjoyed it. I hope you had as much fun as I did. I mean, it was really fantastic. I found it to be very enlightening and highly stimulating. You can't beat it. You can't beat it. Those of you who are in school, the students who are endeavoring, I want to commend you. And I want to say to you that it's your job to change the world. It's your job to make things right. This is not a perfect world, but we're on the cusp of a new day. And I hope that you'll grab it, seize the opportunity to act upon it, and take us where we need to be. I tell you, I wish I was standing in your shoes today. I had my time, and we did some things. We did some things. I saw Professor Jim Coleman was a part of this group. Fine man. I had the chance to serve with him in the General Assembly for capital punishment. Now, we didn't get it overturned in the state of North Carolina, but we got a moratorium on with his fine work and with his intellectual work, and it's still intact today. So people like that, I have the utmost respect for his body of knowledge that he brings. It's an ocean of knowledge, really. This guy is formidable. I give greetings to the Almighty, the Creator. One of my favorite, having grown up in the era of the civil rights movement, I grew up in the 40s, born in the 40s, 50s, and our group said, no more. No more second-class citizenship. We're going to change things. And we went about it. You know, by the time I got to college, that was the 60s. And you know about the 60s, right? Well, the 60s were great times about changing this country. Everybody, black, white, brown, green, anybody American, you on board. Well, you know, it's always the students that lead the revolution. Look at Iran. Look at Tiananmen Square. Look here in America. In South Africa. I spent a lot of time in South Africa. And the kids refused to go to school. We asked them, why did you quit school? You need an education. You need to learn. It's too important. They said, Bishop Tutu was talking to us, said, the answer was, if our parents had done what they should have done, we wouldn't have to do this. So today, and thank God that they kept it up and international community kicked in with sanctions. And the one thing about the South African government, those boys are business people. That's right. They're business people, first and foremost. As long as they can continue to do business and they see they're not going to be hurt, okay, we can deal. And once that became very clear to them that the way out was to change it, you know, business as usual. They changed a lot of things socially. But those boys were able to make that transition. They took the country by the lead. Can't say the same thing about our business people in America, but they're outsourcing all the jobs and everything. I mean, talk about a jobless recovery. I mean, that's oxymoron. That's crazy. It's insanity. A jobless recovery, and I guess so. All the jobs, you know, you better learn Chinese and Japanese and Spanish, because that's where you're gonna have to go get the job if you want to work. We're gonna train our kids to go everywhere else to work. I want to talk. That was I had a good experience. We talked about pluralism. The lawyers and professors were talking about pluralism in America. There's a sister up in Greensboro, a Muslim sister, and she was in court for a domestic dispute. She asked for a Quran. The judge said, bailiff, go find us a Quran. After search, nothing. She said, I would like to have a Quran. Well, long story short, they went on with the case. ACLU got involved in it and litigated the matter. We got to have Qurans in the courthouses. This is not fair. This is not the American way of things. I mean, went to court, Superior Court, they prevailed. State of North Carolina, Attorney General said, well, we're going to look at it and see if we will appeal it. They had 30 days. About the last week of it, I talked to some friends of mine, and he said, man, he said, you all can defend that. I said, well, he said, go to the Constitution. Went to the Library of Congress, looked into the records, and looked at the speech, First Amendment. They talked about a pluralistic society, a no respecter of religion. And people that talked was a delegate named Johnston. They have a county named Johnston County. Those of you from North Carolina might be from governor. He became the governor. Guy-Uriel was another one. That's another county down near Charlotte by that name. He was a delegate. All these guys spoke about the Mohammedans, and their right, and their value system, and this and that. Clay as well. Flawless presentation arguments. Supplied it to the AG offices. Now, you can overturn this and you can appeal if you want, but you will certainly fly into the face of constitutional history. The Attorney General let it stand. Didn't move. So now, I wrote all the embassies in America, asked them, I said, listen, we're trying to get Qurans in all the courtrooms in North Carolina. I ended up about like 3,000 or 4,000 Qurans in my office. I'm surprised they didn't put me out the building over there. Hey man, this is a separation of church and state. What are you doing all these? But we got them, and when they had the state conference, they sent the people over and they picked up the Qurans and gave them to the clerks, and they took them back, and there's no excuse for that. But I thought that was a great celebration of the American spirit and what the country really is all about. America has always been a country of underdogs. We root for the underdogs. You know, we favor top dogs, but we root for the underdogs. And somehow or another, we've gotten away from that. You know, and that after 9/11, we've had so much. You know, the UK, I don't think they got the Rush Limbaughs and, you know, the white right wing, the attack industry. And these guys make good money. You know, it's a business for these guys, Peter. You know, these guys, him, Mark Savages, Glenn Beck. I mean, Glenn, we've taken them all on. And one, either with the sponsorship settlements or the courts, about the defamation issues. It's only so far you can go with this thing until you do irreversible harm, irreparable harm. And this has been the result of 9/11, manifestly, Islamophobia. You know, I don't know, you don't have to read a Quran. You can read a lot of books out here on Islam. You can go on the internet and learn. You should learn it. You should undertake a study to learn about Islam. Same God, all the way through, from Adam. Always, the people, I do a lot of international interfaith. Same people at the top, a lot of cardinals sitting over here, a lot of rabbis, professor rabbis, and Muslim sheikhs, the learned people. Ain't no disagreements. We don't have any disagreements. It's amazing. Why is it that it doesn't filter down to the rest of the world? Well, there's this thing called divide and conquer that's operating out here. You know, you make money off war. You can't make money off peace. You know, I think our budget now totals the combined, our defense budget totals the combined defense budgets in the world. Now that's not, you know, we talking about conquerors. Boy, things have changed. Islamophobia. It's a global epidemic that takes forms in different places and different times. Fundamentally defining Islamophobia is the fear of Islam. Those who suffer from this problem we call Islamophobes and are either motivated by prejudice or simply misguided by ignorance. Ignorance can be a very formidable opponent, but can be tempered with access to resources on Islam and interfaith dialogues. Prejudice needs to be offered the same hand that our prophet Jesus offered to his opponent, but at the same time needs to receive a measured, thoughtful, and coordinated response. We first must know how to identify Islamophobia, figure out to what extent it causes problems in our country and thereby affecting us globally, to the extent that it shows itself, manifests itself in our foreign national policies as well as domestic. In some cases, the wisest policy of responding is not responding at all. In other cases, timing is as important as the message. I will discuss these issues in details, brevity, and elaborate on the proactive projects that we have used to combat this ailment. I'm the chairman of CARE. In the news networks refer to CARE as an unindicted co-conspirator. This is something that is very foreign in the history of the jurisprudence system. We don't name unindicted co-conspirators, but somehow or another, as the Congresswoman talked about it, it got out. But more importantly, it appears that all of the Islamic organization and prominent Islamic leadership, an unprecedented and astonishing 307 people were designated as unindicted co-conspirators. Now, we have never had this to happen in the history of our country, and the courts frown on this. The U.S. Attorney General Office manual explicitly prohibits the naming because you don't have a chance to prove yourself. You don't have a chance to defend yourself. And that is opposed to our adversary system of justice. Islamophobia is in every country and essentially comprised of rational prejudice, fear of Islam. Islamophobia manifests itself in society through biased media, violence of Muslim, discrimination, stereotype, and thereby alienation. Finally, and most importantly, by argument, government policy, foreign and domestic. People fear Islam, are simply ignorant of reality, and in some cases they have been influenced by those who harbor prejudice against Islam. Those afflicted by ignorance eventually are led to see Islam as inferior, uncivilized, monolithic, unable to adapt to the times, barbaric, irrational, violent, supportive of terrorism, militancy, and failing to share common values with other faiths. In regard to those who are prejudiced against Islam, when they become active, coordinated, and well-funded, you will see their works highly influential in circles of media, politics, and society. Geert Wilder is one of the new Islamophobias on the block, and he vigorously promotes his video, Fitna, a movie that likened Islam to Nazism. Just some months ago, he hosted a movie showing for the members of the U.S. Congress.